Well, a debtor might bring a dischargeability action because there is a debt that the debtor will end up having not discharged unless the debtor challenges the non-dischargeability nature of the debt. That can include a student debt. Student loans are not dischargeable unless the debtor initiates an adversary proceeding and is successful in convincing the bankruptcy judge assigned to the case to declare the debt is dischargeable. That's maybe the most common. Another is determining whether a tax debt is dischargeable or not. Generally, there's a mechanical test, a somewhat complicated test, but a mechanical test to determine whether a tax debt is dischargeable, but there might be a dispute over one of the factors. And so the debtor might initiate the adversary proceeding to get the bankruptcy judge to say, yes, all the requirements are satisfied and this tax debt will be discharged. So those are really the ones that come up. They don't come up nearly as often as when a creditor initiates a non-dischargeability action, but they do come up occasionally. So those are maybe the two most common debtor-initiated dischargeability actions. Maybe there's a dispute over whether or not the debtor owes a spouse or former spouse. I think everybody knows that child support and alimony obligations are not dischargeable in bankruptcy. That doesn't matter what chapter the debtor files under. It doesn't matter if you think your ex-spouse is Satan incarnate. If you owe child support or alimony to that ex-spouse, you're not getting rid of that obligation in bankruptcy. But there is another kind of a debt to a spouse or a former spouse that was incurred during the process of a divorce decree or a marital settlement agreement that isn't domestic support. That kind of a debt is not dischargeable in a Chapter 7 or a Chapter 11, but it is dischargeable in a Chapter 13. And let me give you a simple example to illustrate what kind of debt could come up. Let's say in the dissolution of the marriage, going through one of the steps, the assignment of debts, there are 4 debts. Maybe one to Bank of America, one to American Express, one to Chase, and one to Capital One. So the divorce judge says, I order you, debtor, to pay the American Express and the Bank of America. I order you, the other spouse, to pay the Chase and the Capital One. All right. Debtor goes through a bankruptcy later on. All 4 creditors are stopped from ever trying to collect that money from the debtor. But let's say the ex-spouse is making the Capital One and the Chase payments, but isn't making the American Express and Bank of America payments because from that ex-spouse's perspective, that debt belongs to that person's ex-spouse. Well, Bank of America comes knocking on the door of that ex-spouse and says, hey, you owe us this money, pay us up. And that ex-spouse says, oh, no, my ex-spouse is the one that owes the debt. That was assigned in the divorce decree. And Bank of America is going to say, hey, you can't prejudice our rights by shuffling paper between you. You pay us. So what's that ex-spouse going to do? It's going to go to the divorce judge and say, hey, Your Honor, you ordered my ex-spouse to pay this debt. My ex-spouse isn't paying the debt. They're coming after me. Order my ex-spouse to pay me so I can pay this debt. And of course, the divorce judge will grant that request. So what kind of a debt do we have here? It's a debt to a spouse or a former spouse that isn't support. If you go through a Chapter 13, that debt is dischargeable in bankruptcy. Now, that particular debt, I think, is not particularly ambiguous, but there are other kinds of debts associated with divorce that are a little bit murky. How about the attorney fees that were incurred as part of the divorce proceeding? Is that support, or is that in the debt that is to a spouse or a former spouse that isn't support? And it depends on where you live, because there is case law on one side of the road and case law on the other side of the road. And here you'd end up having to, here in California, you'd have to use California state law to determine that. Even though bankruptcy is federal law, if there is a state law question then you'd have to turn to California state law. So this is where it gets to be a little bit murky. And so a debtor might want to initiate an adversary proceeding if enough money is at stake to have a determination that this particular debt is not support and therefore would be dischargeable into Chapter 13. And in that Chapter 13, then the debtor might pay a small fraction of the debt and the rest of it is discharged. Certainly the debt to the 4 credit card companies that I mentioned earlier, those debts would be dischargeable anyway, unless there were fraud debts. But a debtor might want to get a determination that a particular debt to a spouse or a former spouse is not support.